Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hi, everybody. Welcome to the next issue of Triage. My name's Leah Richardson, and I'm joined by my partners, Darlene Davis and Andy Ruskin from K&L Gates Healthcare Regulatory and Transactional Group. And today we are going to talk about the CMS's proposed rule, the hospital outpatient prospective payment system remedy for the 340B acquired drug payment policy for calendar years 2018 to 2022. The pre-publication version was issued on July 7th. The official version was published in the Federal Register on July 11th, and it has caused a big storm of conversations in our world of hospital and pharmacy and 340B, and so today we're going to talk about that. So first I'm going to turn it over to my colleague Andy Ruskin, who's going to start with kind of the background of how all of this happened.
Yeah, thank you so much, Leah. So just to recap, the past 5 years of developments on the world of 340B drug reimbursement under Medicare. In 2017, the Trump administration published a rule that would pay 340B covered entities less money under the outpatient payment system for drugs that they purchased under the 340B program. That went into effect in 2018. It was widely viewed as being outside of CMS's statutory authority. So the American Hospital Association and a couple of other trade associations sued CMS. They won at the district court, and the district court allowed its decision to remain on hold while CMS appealed to the appellate court. The appellate court overturned the district court, and AHA and others took the case up to the Supremes. The Supreme Court, in an unanimous decision, found that CMS had acted outside of the scope of its authority in terms of how it interpreted the drug reimbursement rules. It did not insist on a particular remedy, and instead it remanded the case back to the lower courts. The district court ultimately received the case and bifurcated it into two decisions. One decision came out in September of 2022, where the district court said, we don't care about your concerns about budget neutrality, CMS. You must fix the payments you are making for drugs purchased under the 340B program immediately. CMS acquiesced, and for the remainder of 2022 and into 2023, CMS started paying for these drugs. Instead of at the underpayment rate of ASP minus 22.5%, they paid at the statutory rate of ASP plus 6%. And then the same court, however, said, we're not going to fix the prior 4 years of underpayments. Instead, we're going to allow the agency to address whatever concerns it may have with respect to rulemaking, and we can do whatever we need to do on the back end after the agency takes its action. So CMS, a couple weeks ago, as Leah just pointed out, issued its proposed rule, and not to keep everyone in suspense, but I'm going to turn it over to Darlene to talk about what that rule entailed.
Yeah, so the rule has a couple of really interesting components, which we'll talk about. The first is that CMS is proposing for, fee-for-service Medicare, a lump sum payment to each effective 340B hospital. Because CMS, as of September 28th, had instructed the MACs to begin paying at ASP plus 6%, the proposed rule really focuses on the amount the hospital would have been paid from calendar year 2018 through September 27th of 2022. And so CMS would essentially determine the amount for each hospital by assuming that, starting out with sort of the lump sum of $10.5 million for that period, calculated across all hospitals, and then assuming that $1.5 billion in remedy payments had already been made due to reprocessed claims because providers have been getting paid through requesting adjustments in some instances for reprocessing claims through the MACs for the period of January 1st, 2022 through September 27th, 2022. And so CMS comes up with, by subtracting that $1.5 billion out, comes up with a total of $9 billion that they're saying would be the amount that would be divided among the affected hospitals to determine each lump sum amount. And that $9 billion does include beneficiary cost sharing. So there would be no cost sharing collected from beneficiaries. CMS has published on its website an addendum. It's addendum AAA, which actually breaks down the anticipated payment by each hospital. So we'd encourage affected hospitals to go ahead and take a look at addendum AAA and see what that estimate is for your particular hospital. And again, that's on the CMS website. In terms of the timing of that payment, CMS is proposing to issue instructions to the MACs on making that lump sum payment. And they're essentially, again, this would be a one-time lump sum payment amount. And they're proposing that the MACs make that payment within 60 calendar days of receipt of instructions from CMS. So that part of the rule is really sort of focused on the lump sum payment to affected hospitals as the remedy for those underpayments from calendar year 2018 through September 27th, 2022.
So, Darlene, how is CMS going to pay for all of this?
Yeah, that's the other big component of the rule. And I'm going to turn it over to Andy to talk about the proposal related to budget neutrality.
Thanks, Darlene. So CMS, quite frankly, doesn't have to have any sort of a payment mechanism for the rule whatsoever. It is able to pay damages in litigation just like anybody else can. However, CMS has tried to take its concerns regarding how much money it's going to be distributing to Medicare providers into account by basically putting a square peg into a circular hole. It claims that it has one of two different statutes it can rely on as to why this is either viewed as a quote-unquote equitable adjustment under the statute, which requires a budget neutrality adjustment, or alternatively, that CMS is making expenditures in implementing the statute that, with respect to drug payments, that also would require a budget neutrality adjustment, when in truth, what CMS is doing is following instructions from a court that says that it has acted outside of its authority and needs to make providers whole. So it really does not fit within either of these rules. CMS is also trying to argue as a backup that it's able to engage in this rulemaking through its retrospective rulemaking authority, which is interpreted very narrowly, and in any event, that doesn't really tie up neatly with the truth here, which is, again, these are damages. CMS even calls this a remedy for its loss in litigation, and because it's constantly striving in the rule to characterize this as something it is not, it looks like CMS is treating the language out of the context in which Congress intended for these particular provisions to be used. And one can speculate that therefore CMS is inviting future litigation because the whole reason it was sued with respect to the ASP minus 22.5% formula was because, again, it wasn't being very genuine in terms of its interpretation of the statute. So same here, this CMS is, if it goes forward with this in the final rule, it is actually inviting future litigation. The way that CMS is implementing the budget neutrality adjustment is by essentially taking a 0.5% reduction over the next 16 years, but not beginning until 2025, basically giving providers and their trade associations a chance to see what they can do to get this undone, either through Congress or potentially through litigation. But once 2025 hits, then providers will, through dribs and drabs over 16 years, start to feel the pain of the payment reduction, and it will be every provider. The CMS isn't just going to target the safety net providers with the budget neutrality adjustment, but every provider. CMS has said that every provider got a quote-unquote windfall, even though CMS itself had viewed the payments as a reasonable payment on the originally, and only now is recharacterizing them as windfalls to serve its current objective. What's interesting and to some extent telling to me is that CMS also says that even if it doesn't have to do what it plans to do in terms of a budget neutrality adjustment, it said that it nevertheless believes it has the authority to do it, in that as a matter of quote-unquote public policy, it will do this. That to me signals that CMS is making a political calculation that the electorate would agree with them that this is the right answer. Providers are, of course, major employers wherever they're located, and they should make it clear to their members, their elected officials, that this should have political implications for especially the executive branch if they move forward with this. Since this is absolutely not the right outcome, CMS is essentially punishing providers for its own mistake in terms of publishing this rule back in 2017 and implementing it in 2018. So providers really should be focused on whether or not their trade associations are protecting their interests in litigation, and whether or not their political vehicles are making it clear to the current administration that they do not believe that this is good policy at all, contrary to what CMS has said in the rule, and should consider what avenues of redress they have in that regard as well.
So, Andy, it sounds like all hospitals need to be thinking about this issue with budget neutrality, not just the 340B covered entities that are getting the lump sum payment. And it sounds like, like you noted, they'd be, should be thinking about things like their trade associations and other avenues they have to analyze and seek redress on this issue. And we've been talking about this all in the context of fee for service. What about Medicare Advantage? What are the implications for Medicare Advantage?
Oh, absolutely. For certainly, even beyond just the budget neutrality issues, which definitely carry over to the MA plan side of the world, even the lump sum adjustment aspects have an MA plan component to that. Why don't you talk about the MA plans and the 340B make whole payments, and then we should also absolutely round back to the budget neutrality issue as well.
Thanks, Andy. Yeah, let's discuss what the proposed rule doesn't address, which is how to remedy those reduced payments under the Medicare Advantage contract. So, as many in the audience will be aware, the reimbursement for these affected services here in many of MA plan contracts is based on a certain percentage of the Medicare rate. So, for example, the contract might state that the hospital will be paid 100% or 105% of the Medicare fee-for-service rate. Well, so in 2018 through most of 2022, that was ASP minus 22.5%. And, as many of you also know, up to half or even more than half of a hospital's reimbursement for Medicare beneficiaries may come from MA plans. So the implication is if CMS's payments on the fee-for-service side were unlawful and hospitals must be repaid, then the MA plan payments were also unlawful, and those plans should also be offering a similar remedy to hospitals. It's possible that some MA plans may follow suit and pay hospitals a lump sum. That's probably unlikely in the majority of cases, and then MA plans are likely to take the position that these new rates are prospective only, and that the CMS payments, that these lump sum payments don't have any impact on their relationship with hospitals. So many hospitals had already been preserving their appeal rights related to some of these reduced payments historically. But given that we're 7 months into 2023, almost 10 months from when the court said, CMS, thou shalt start paying at ASP plus 6%, most of the claims are going to have timed out under any kind of reconsideration or appeal regime. But hospitals still should be aggressively demanding repayment from these MA plans all the way back to January 1 under a breach of contract theory, not under a claims appeal process, but under a breach of contract, and demanding those payments once the CMS final rule is published. we're going to acknowledge that it'll be an uphill battle, but we are actually aware of a few MA plans that have repaid hospitals the full amount back to 2018. That's a rare thing, but it has happened. We've seen it, and hospitals really need to be going after this money. It's a material part of the losses that hospitals have sustained based on this unlawful reduction.
Sounds interesting, Leah. What about the budget neutrality aspects? Obviously, that hasn't gone into effect yet. Would you suggest that providers also figure out a way to go after MA plans if and when they put into effect a reduction similar to CMS's reduction?
Yeah, I think there's a few options. Some that are going to have to wait until that actually happens. So, as soon as you start getting those reduced rates across the board, you can start, preserving your appeal rights related to claims. You can also just institute litigation. But what might be a better, route practically, particularly if your hospital is in the position of currently kind of renegotiating with some of your MA plans, is to just preemptively contract around that issue so that you're not agreeing, right? If you're in the middle of contract negotiations, in other words, right now or anytime in the near future, you want to make sure they're not going to implement any kind of budget neutrality regime. And you'll have to look at the contract language really carefully, and probably will might need some lawyers to help you with that legalese.
I think we've covered the aspects of the rule both from a fee-for-service perspective in regard to the lump sum and in regard to budget neutrality, and also discussed considerations around MA plans in both regards. So thanks to you both for an informative triage, and thanks to our listeners. And we would just note that if you do want to submit comments, and this is an area that you very well might want to submit comments on, these various aspects, they need to be received no later than September 11th, 2023.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.